Again, this is the Charlotte Triage Pro Bono Partnership annual event, CLE, for the human trafficking area of focus. So excuse me, we're having a little bit of technical difficulty. Just give me 30 seconds. Okay, so in years past, we have provided training on Human Trafficking 101, trauma-informed legal representation, and we've also heard from Triage volunteers who've provided expunction, family law, and criminal defense support to survivors. But today we're going to provide some new content for a really important area of survivor support. As you'll hear in a few minutes, the Trafficking Victims Protection Act provides immigration relief for human trafficking survivors with the dual intentions of both protecting victims and also assisting law enforcement in their investigation and prosecution of human trafficking crimes. These humanitarian remedies provide critical stability and protection for foreign-born survivors of trafficking and other crimes. This relief is so important because it can provide lawful status, the possibility for employment authorization, and they often include a pathway for lawful permanent residence. Most importantly, survivors who receive one of these immigration benefits that you'll hear about today may be protected from removal and the threat of harm or retaliation in their home countries. Charlotte Triage has a few committed immigration attorney volunteers, but very candidly, we need a deeper bench. We were recently alerted to a forced labor case under investigation in our area that may result in several victims needing assistance with their immigration needs. So today is a call to action to train more of us and convince more of us that we are competent and poised to take these cases on when they come our way. This is so important that we imported a national expert in this space to provide over video feed our training today. Today's CLE is delivered by Jane Anderson of Aequitas. Aequitas's mission is to improve access and quality of justice in gender-based violence and human trafficking cases. They train law enforcement, prosecutors, and attorneys on prosecuting human trafficking cases and supporting victims. Aequitas and Jane in particular have been friends of Triage for some time, and they provide us tremendous support. So a few housekeeping items. Please submit all questions related to the training into the chat function, and they'll be answered following the program over email. Also over email, you'll receive follow-up information about the program, the CLE attestation form that you need to fill out in order to get the CLE credit, and you'll also receive instructions on how to access our virtual video library of other human trafficking related trainings. Some I'd mentioned above, but they include Human Trafficking 101, credit repair work, and trauma-informed lawyering. So to begin our program, I'm going to announce the first CLE code, which is AQR179. So A is in Apple, Q is in Queen, R is in Robert, 179. And with that, we'll begin the training video.
And at this Charlotte Pro Bono Triage Partnership third annual event. I'm really excited to share with you a little bit about immigration relief that's available to victims of human trafficking. My name is Jane Anderson, and I'm an attorney advisor with Aequitas. Aequitas is a nonprofit primarily grant-funded organization based in Washington, D.C. We're made up of a cadre of former prosecutors who all specialized in cases involving domestic violence, stalking, sexual assault, and human trafficking during our careers. I'm a former prosecutor from the Miami-Dade State Attorney's Office, where I started my career prosecuting cases of domestic violence and stalking in our misdemeanor domestic violence unit. Worked my way up through the office, prosecuting homicides, drug trafficking, really anything you can think of. But I always focused a lot of my energy on handling those cases that involved a little bit more of the complex dynamics when offenders and victims know one another or there's a relationship. So cases of sexual violence, child abuse, elder abuse, felony domestic violence. And then the last part of my career, I had the opportunity to start our human trafficking, well, what started off as a task force of one, me, and then, no, that's an exaggeration. Of course, it took a bunch of folks from our community, but I had that first case land on my lap where everyone was like, what is this? And then we quickly learned through our steep learning curve, through a partnership with community-based partners and organizations, that we were really not looking at something new, but rather looking at something old through a new lens. So I was fortunate enough to try most of Florida's first state-level human trafficking cases before and after a legislative change. Tried some labor, some sex trafficking, primarily sex trafficking. And then I moved on and joined Aequitas, where I head up our human trafficking training and technical assistance program and provide support to a lot of prosecutors and also allied professionals around the country. We recognize that combating human trafficking takes a holistic approach, and so that's how we approach our training as well. So that's one of the reasons why I'm particularly excited to be able to provide this information to this particular audience, made up of some key folks that can help support survivors as they hopefully exit human trafficking. So at Aequitas, we strive to provide innovative, informed, and hopefully really practical strategies that you can implement, kind of on day one, expanding your toolbox of resources. We do that in a lot of different ways, including training events such as this one, a lot of which is now, of course, via Zoom and other web-based trainings. We're getting started doing some more in-person trainings as well, slowly but surely. But our website is full of public-facing resources, research, publications, and also webinars. So feel free to peruse those. We also offer 24/7 consultations. In reality, hopefully there's not a lot of 2 a.m. calls needing training and technical assistance, but we really love the work where we're sort of digging in with a prosecutor or attorney or even detective on what to do with a particular case. And so a lot of those consultations might be being a sounding board for jury selection questions, or trying to help a law enforcement officer work with a prosecutor's office who may not be as used to some of these issues that come up. And more, especially in our human trafficking work, we work with immigration attorneys, victim rights attorneys, and so forth. Anyone whose work really intersects with any of the crimes that we focus on in the criminal or civil justice system. We're also involved in a lot of partnerships and initiatives, and invite you to learn more about those. One of which I wanted to highlight for the purposes of this presentation is we work with a 8-member survivor advisory council through our Just Exits initiative. And through that initiative, we're working with 3 pilot sites across the country, trying to sort of minimize those on-ramps to exploitation and criminalization and maximize off-ramps. And that's all been really survivor driven. And I know personally, I learn something new every time I'm engaging with that initiative. Feel free to follow Aequitas at any of our social media platforms. We do consistently push out training opportunities, new research, new resources. And so I'd invite you to just check out our website or follow us on any platform that you feel comfortable in your professional capacity. So today, we're going to first and foremost talk about the three primary forms of immigration relief that are available to victims of trafficking. That's the T visa, the U visa, and continued presence status, or CP. They all have a little bit of their intricacies, and so we want to dive down a little bit and figure out which one might be the best for a victim you may be working with, a survivor that is trying to gain status in the United States. I want to think about these sort of visas and status. I want to think of those as tools for law enforcement. And one of the reasons we want to do that is because most require some engagement with law enforcement for a survivor to access or apply for this type of relief. And so we'll think about the tools as a way to improve victim participation in the criminal justice system and the civil justice system, although that's not obviously as much as my experience on working with the U visas, T visas, and continued presence. And then lastly, I want to encourage folks to consider victim safety as the primary reason for why we are going to be working with survivors, law enforcement, prosecutors, in order for them to gain immigration relief benefits that they are entitled to. So when we think about human trafficking, and obviously I'm not going to do a deep dive into what is human trafficking, but I want to focus on some of the challenges that we have in identifying human trafficking and working with victims of human trafficking. In this context, obviously, immigrant victims of human trafficking. And when we think about this lack of disclosure, it's one of the primary challenges that we have. There are about 3 buckets of reasons why we see that victim survivors may not come forward, may not tell us what's going on. You know, they're not calling 911. And I'm sure some of these immediately come to mind, but I think about it in 3 buckets. One of being misconceptions, one of being barriers, and of course, fears. And fear is not, just related to potential, of course, physical violence that they might receive at the hand of their traffickers if they were to find out that they reported this. But we have fears of deportation. And again, that fear of deportation is not just a single level of fear. It comes with it additional fears, such as the dangers that they may face in their home country, family separation that may occur, retaliation to themselves, to their families. We know that recruitment in labor trafficking cases often involves recruitment through social and familial circles. So it would not be uncommon or even a small stretch of the imagination to learn that the trafficker and their related recruiters and other employees, they'll know where this victim lives, the community from which they come, their family members, relatives, and friends. And so this threat of retaliation is a very real and present one. There are also more sort of subtle things that I would think about, which is the fear of being shamed. Some survivors report that the idea of having to return to their home country empty-handed is a real sort of threat of being shamed. That the entire family may have relied upon them to be making this trip to the United States and to be therefore being the one person that's going to sort of help the entire family come forward. And so that with that shame, that can be a lot of fear as well. We also want to think about debt and a loss of collateral. The research tells us that debt bondage is a primary form of coercion used in labor trafficking, and also that collateral, upfront fees, and upfront debt before even someone comes to the United States is also quite common. So a victim of trafficking, in order to have the upfront money to make the trip to the United States, they may put their family land up for collateral. And so the fear of reporting, therefore losing their job, therefore maybe being deported, all of that then comes also with the fear of, I still have an outstanding debt and my family's home may be subject to this collateral that we promised before I came to the United States. So there's a lot going on when it comes to fears. There's also a lot of misconceptions. So victims of human trafficking have their own experience, immigrant victims, of how the police works and how the system works in their country of origin. And with that may then become a lot of misconceptions about how the police in the United States will work and how they are tasked. So we'll often hear that, victim survivors do not differentiate between local police and FBI and ICE. It's all sort of one system of police. And so to be able to sort of share with a survivor, hey, no, I'm a local police officer, or I'm FBI, I have nothing to do with immigration, is going to be a barrier because there is this misconception. Also, just that police will not help. Maybe that they don't believe that the criminal justice system is something that they have access to as a non-citizen. We hear that from potential jurors when we try cases involving immigrant victims. Jurors in our jury panel will often or commonly, or not so uncommonly, express that they don't believe the criminal justice system should be accessible to non-citizens. So that's a bias that we have to work on both ends here. Similarly, have no idea what human trafficking is or what labor laws they may be subject to and have the rights under here in the United States, even if it didn't rise to the level of trafficking. And then with the barriers, obviously there's a language access issue that comes up quite often. Victim survivors are not aware of all the services that are available to them. They may lack basic things like childcare or transportation that are needed for them to then take, to access services or to go through these various processes, which of course would be very daunting for someone not from the United States. I mean, it's daunting for people from the United States. So you can only imagine. And of course, if they're leaving their job, they may not have the ability to find other work. And definitely they may not have work authorization and subsequently not have any ability to pay for an attorney to sort of help them through this process. So all of that said, all of these misconceptions, barriers, and fears, more than I even discussed, but those were some of the most common that we hear from immigrant survivors of human trafficking. A lot of those are things that can be minimized, not eliminated, but minimized through immigration relief tools. So that's why it's so important from the outset to really understand that the immigration relief that's available to victims of trafficking, these were designed to help victim survivors be able to disclose, to speak to law enforcement, to participate in an investigation, and ultimately with the hopes that offenders could be held accountable through successful prosecutions or civil litigation. With that in mind, there are 3 forms of immigration relief that I'll go through. So first off is the T visa. That's a temporary immigration relief that's available only to victims of human trafficking. So a very specific visa for victims of human trafficking. The U visa is a temporary immigration relief available to victims of a variety of crimes, of which human trafficking is one, as well as a lot of co-occurring crimes related to human trafficking. And the third is continued presence. This is a short-term immigration relief that's available to victims upon immediate identification as a potential witness or victim, if there is a sponsorship from a federal law enforcement officer. That's that sort of last caveat there that we'll talk about in detail as we move forward. So the TVPA enacted the T-Visa to strengthen the ability of law enforcement agencies to investigate and prosecute serious crimes and trafficking in persons while offering protections to the victims of these crimes without having this immediate risk of deportation. Following up, it was also meant and enacted to strengthen relations between law enforcement and immigrant communities. This comes from the Department of Homeland Security's T-Visa Law Enforcement Resource Guide. So this is really important language if you are working with a survivor of trafficking and you're trying to sort of engage with law enforcement or the prosecutor's office because you're asking them for their support in your application. There's a lot of misunderstandings about what these are. What is a T-Visa? What is a U-Visa? And there's a lot of sort of misunderstanding. People think they know what it is. I think more often than not, the real thing is what it is not. But as an attorney supporting a survivor through this process, one of your goals and responsibilities is most likely going to build a relationship with your law enforcement prosecutor partner that you're trying to work with. And to sort of alleviate these fears that come to them, this is really great language to share with them. These are tools. These are tools for law enforcement. It's so that law enforcement can identify offenders and hold them accountable. And they can do that because victims are going to be more willing to work with them, not as afraid that they'll be deported during the pendency of a case. And they're going to have some of those protections, hopefully, as that investigation and prosecution go forward. So that's kind of the micro level intent to help with particular cases, to help particular victims, to hold particular traffickers accountable. The second piece of it is the macro piece. And this is a piece where when I train law enforcement and prosecutors, which I'll admit is my primary audience when I'm presenting on U and T visas. So I'll hopefully will present a little bit from their perspective and some of the common fears and misconceptions I have from law enforcement and prosecutors. And that may guide your ability to sort of navigate your survivor's application. So this macro level goal is sometimes a little bit harder to get over because as a prosecutor, for example, I'm worried about my case. And I know that sounds really terrible and that probably shouldn't be the way, but this is the reality is like, well, how is this going to affect my case? Well, if I don't have a case or I don't have a strong case, then why am I going to give this benefit to somebody? That goes through folks' minds. So we have to kind of reframe it and say, this tool is not necessarily for your case or particularly for that one victim. Yes, that one victim will get a benefit if everything goes well, but the reason behind the entire process, the reason why we have these tools is a bigger picture. It's to help build these relationships within communities. And so we got to keep our eye on that bigger picture sometimes as well when we're analyzing whether somebody applies or somebody qualifies for these forms of immigration relief. So let's get down to it. A T visa, what are the requirements? The primary requirement is that the applicant is a victim of a severe form of trafficking. Now that sounds like it has to be like trafficking plus, but it does not. It just mirrors the severe form of trafficking, mirrors the TVPA and the definition within our federal laws. And so it's not trafficking plus, all it is they have to meet the federal definition of trafficking, which most states, that definition sort of mirrors the federal one. The victim has to be in the United States because of trafficking. This one catches people up a little bit because sometimes they assume that it has to be that they were brought here for trafficking. That's not the case. They could be in the US for the purposes of the investigation related to the trafficking. So there just has to be that nexus between their presence in the United States and trafficking. They have to respond to reasonable requests for collaboration with the investigation. So again, a lot of ways that can be construed by different entities. And so that often is where we have sort of tension points between somebody that's providing services to the victim, survivor, and law enforcement and prosecutors. They also have to show a hardship upon return to their home country. So those fears that we talked about in one of the earlier slides, that would be a good representation of what types of hardships that they may encounter in their home country. That has to be articulated by the applicant. So law enforcement is not, and prosecutors, which we'll kind of group in with law enforcement for purposes of this conversation, they're not responsible for sort of signing off on all of these. They're asked if they have any information about a hardship upon return to home country, but that's really not the crux of it. Most of the time, law enforcement's signing off on the fact that this person is a victim of trafficking and that they have collaborated on reasonable requests. This is the federal definition under the TVPA of severe forms of trafficking. So you'll see the common language that if you've worked on trafficking before, you're used to, which is the force, fraud, and coercion when it comes to commercial sex of an adult. Commercial sex of a minor does not require proof of force, fraud, or coercion. And when it comes to labor trafficking, it looks a little bit more complicated of a definition, but similarly, it's force, fraud, or coercion for the purpose of forced labor or services. If you have any questions about the definitions of trafficking or your state definition, I know you have access to lots of amazing local experts, but this is another place where Aequitas can help do a statutory analysis or help you walk through that, because we do work with human trafficking task forces all around the country. Almost all 50 states at some point have had a task force, working on North Carolina, but we've done a lot of statutory analysis along the way. So T-visa facts. There are 5,000 allotted T-visas per year. There have never been 5,000 applications per year for human trafficking cases. So this maximum of 5,000 visas a year is never met, which I'm highlighting now because we're going to contrast that in a bit with the U visa, which has a massive waiting list on it. So if you were working with a survivor that you think, oh, it applies for a T visa and a U visa, the goal is to go through the T visa application process. It's quicker. There are available visas every year. And so if you qualify, that really is the preferred method of application. All applications are reviewed, and ultimately the decisions are made and the visas are issued by USCIS, or the U.S. Citizenship and Immigration Services. This is another kind of big point of training. Because law enforcement is being asked to sign this documentation, that's an endorsement is what it's called, they often sort of have this fear that they are giving this immigration benefit. They are conferring citizenship. And in fact, it is really a gatekeeping function that law enforcement's asked to participate in to help the USCIS find sort of a basic probable cause finding. And then USCIS does all the heavy lifting. They're the ones that do the background check. They review fingerprints and biometrics, and they review all the accompanying documentation because law enforcement really only looks at a couple of pages of this endorsement, and that's all they're involved in. So if you're working with a survivor, you're putting together this entire application, you're doing all this, you may have to kind of educate your law enforcement to say, hey, this is just a gatekeeping function. We're really only asking you to sign off that this victim is a victim of trafficking. And the standard by which they are meant to make that decision is reasonable suspicion. That's the standard that DHS has determined is appropriate because of the civil nature of this process. So that's another thing where law enforcement and prosecutors may get caught up because we're used to working in a world of beyond a reasonable doubt. And because this immigration process is a civil process, they don't work with that standard. They work with reasonable suspicion, which is probably not officially, but often described as, 51%. So once this so the endorsement is signed by law enforcement, attorney, advocate, putting together this entire application, submitting that to USCIS. USCIS is going through it, making their determination. And then if a visa is issued, that allows the victim to reside in the United States for 4 years. There is employment authorization accompanying that and derivative T visas for certain relatives. There is a possibility of adjustment of that status to permanent residence after the end of 3 years, where there's an entire other process, again, reviewed by USCIS, and there is a pathway to citizenship. I've provided a lot of additional resources here on these slides, and the slides will be made available to you. So this is sort of what it looks like. The law enforcement declaration is hopefully signed by somebody involved in the investigation or prosecution. There's an application supporting documentation, and then there's the decision by USCIS. The typical length of this is 2 years. That's what I'm told from the field. I literally found something online yesterday that was released by USCIS, and they were saying that the length is a little bit less than that right now, which is good news, but that's still when we're trying to sort of calculate our expectations. This is probably a good way to do it. Who can sign the endorsement? It's purposefully designed that any number of folks can sign the endorsement. My understanding is that was created that way because they knew that some agencies would not necessarily ever sign an endorsement because nobody can be mandated to sign. It is completely up to the discretion of the signing official. Therefore, they wanted to really provide the victim survivors with almost like an ability to forum shop in case that was the issue. So federal, state, and local folks can sign. Law enforcement, prosecutors, judges. We see judges, magistrates, and commissioners sign many times in cases where there's perhaps a family court or a civil injunction court proceeding, and the judges will have that the necessary information to sign. But because of the way that human trafficking and labor trafficking in particular, when we're discussing immigrant victims, we know a lot of those cases come through DOL or EEOC and never really make it to the criminal justice system. Although we're working really hard to change that. That means that DOL and EEOC can sign the endorsement. Investigators with child and elder abuse agencies can sign. Really, any government agency that has some form of investigatory power or investigative power, they can sign the endorsement. Let me show you what we're talking about. This is the crux of the Supplement B or the law enforcement declaration. I think they changed the language, so I go back and forth between endorsement and declaration. But this is the statement of claim. Hopefully you can see it here. The applicant is or has been a victim of a severe form of trafficking in persons. Specifically, he or she is a victim of, and then there are 3 boxes. And this is literally pretty much the entire supplement besides some personal information. I want to see if I can do this for you guys in the middle of our presentation. Maybe it might not work out too well, but I wanted to see if I could bring up, I think I can, let's see. Yeah, so here is the actual form. Supplement B, Declaration of Law Enforcement Officer for Victims of Trafficking in Persons. This is the only form that your endorser, your law enforcement, your judge, whomever, this is the only form that they're asked to look at and to fill in or sign. Oftentimes, when I talk to immigration attorneys or victim advocates that work with survivors, they say that they print out this form and they give law enforcement one form completely blank and one form filled out to the extent that they can fill it out. And then some law enforcement people like to use the one that's all filled out. It's easier. Yeah, just read it, review it, and sign it. And others feel more comfortable filling it out themselves. So we see there's just victim information, agency information, and then these are the statement of claim. Those are the check boxes that I just noted. There's obviously some not applicable or other that would not really be the way that you'd prefer to fill that out. And then it says, please describe the victimization and identify the relationship. Has the victim expressed any fear of retaliation or revenge if removed from the United States? So that's that hardship piece. These are not necessary. If you have that information, yes. If not, and then the dates that you have, and again, it's going to ask for months and days, but you can absolutely fill this out with more broad information. You could say early 2000 to late 2020. You can say a season. Try to be as specific as possible, but they do not need to be in that form. They ask for any citations so that they can cross-reference if you're referring to maybe a state statute instead of the federal statute, what you're actually investigating. Again, that's really just helpful for them to make sure that it is sort of matching up with the federal definition. Some dates about your investigation, and then cooperation of the victim. Has complied with requests for assistance, has failed to comply with requests, has not been requested, has not yet attained the age of 18. And there's some others. We've had cases where it was an adult, but it was somebody that was developmentally delayed or somebody that was incapacitated. So there's, of course, exceptions to every rule. Something can make this more complicated if it needs to, but I wanted to just sort of show how potentially simple this piece of it could be. It asks about family members implicated in the trafficking. This really is because they want to make sure that when they enter information into the system, they have those family members that are potentially offenders in there. This is because the research shows that traffickers, even if they're family members, are going to call and try to get this victim deported in a way to escape accountability. So they put in the system, there's literally a red flag in the system when anyone applies for a T visa or a U visa. And that red flag tells officials like, hey, there's an application that's been submitted, it's pending. And the executive orders say, do not initiate deportations proceedings. And FYI, here are some of the offenders' names. And oh, that happens to be the person calling right now, or the person that's, giving some information to ICE. That's why that's in there. And then the bottom is the attestation, which says, based upon the facts, the investigation, I certify under penalty. This person is a victim of trafficking. I certify as true and correct to the best of my knowledge that I've made no promises regarding the victim's ability to obtain the visa. And I further certify that if the victim unreasonably refuses to assist in the investigation or prosecution of the acts of trafficking of which she is a victim, I will notify USCIS. That last sentence is really helpful when you're trying to get this attestation signed. And one of the reasons is that law enforcement and prosecutors are very nervous that they're going to learn something new. And all of a sudden, they're going to realize that this is a big fraud that's been perpetrated against them, or that this person wasn't, in fact, a victim. They may have been a perpetrator. We have this fear that we're going to find out more information tomorrow, and all of a sudden we'll be like, oh no, we signed that. So this is a way that I usually sort of calm some of those fears. This not only can you, go back and provide more information, you're actually promising that you will. You'll provide that more information down the line. And also with the lack of, collaboration or cooperation, you might think, okay, they're being really cooperative, but I don't want to sign this until I get everything I need out of the victim. because I don't want them to stop cooperating with me because now they've got their endorsement signed. So no, this has this continuing obligation on behalf of the victim. So that can, again, assuage some of those fears that we commonly see in law enforcement and prosecutors of why they don't want to do this or why they want to delay doing this. And that's a big piece of it when we start looking at these timelines. You don't want to be delaying this application any more than you have to. And so you want this endorsement up as soon as possible. So we tell law enforcement and prosecutors, as soon as you have reasonable suspicion that they're a victim, sign this, get the process started, start trying to protect your victim and trying to protect your case. Because when they have the stability of work authorization and the fear of deportation is alleviated, you're actually going to have a better victim that's going to be more comfortable disclosing, more comfortable participating in the process. And so this attestation, which can kind of seem a little bit scary, can actually work in the benefit of you as well. And that is it. It is 3 pages long. That's all that the law enforcement officers are being asked to sign. So now we have, let's see, I think I've got to, yeah. So reasonable requests for assistance. There is this general guidance that's provided by DHS, but in reality, it can be anything. It can be that they participated in an interview, that they looked at a photo lineup, that they signed release for medical documentation that was important to the case. Maybe they participated in a controlled phone call, identified offenders, or even identified other victims or other witnesses. So this is just an example of what would be considered assistance. And it can be much broader than this. And really the only thing that DHS does is they provide this guidance that says, whether a particular law enforcement request is reasonable depends on the totality of the circumstances. So not only does the victim have to they have to comply with requests for cooperation, but they have to be reasonable requests. So what is a reasonable request? And they say, oh, this depends on the totality of circumstances. So lawyerly of them. But USCIS goes ahead and says they're ultimately the ones that make this decision. So document, rate what your thoughts are. As a law enforcement officer, I always say, look at what you were asking them to do, look at the force, fraud, and coercion that they experienced and determine whether that was reasonable or not. Some things you should be thinking about is, what was the nature of the victimization? What level of trauma did they experience? What kind of fear do they have? For a victim of trafficking, not to immediately disclose everything on first interaction with law enforcement, that is expected. It would almost be strange if it wasn't that way, because we know about all these fears, misconceptions, and barriers. So if you're supporting a victim's application, you may need to, kind of talk through that with law enforcement officers, or say to them, they are willing to sit for another interview now that they've been put in place with services. They're in a safe spot. Maybe we can do another interview. So it can be a time where there's this sort of negotiation. I hate to use that word because that's really not the right word, but you may have to sort of sell your victim's participation to law enforcement and also expectations of what cooperation might look like in the future. There is a trauma exception to the T-visa, and this says that certain victims do not need to comply with those reasonable requests for cooperation because they've experienced such a high level of trauma that they're unable to participate. And so that's the discretion again at USCIS, and they must to have this to apply without that cooperation, there must be an affirmative statement from the victim. It is highly, highly, highly recommended that there's some sort of accompanying medical evidence that goes along with that affirmative statement describing the trauma. One of the things that's interesting about the T visa is that you can actually apply for a T visa without that law enforcement declaration, that 3-page declaration we just went through. That's not a necessary piece of the application. And again, that's going to be contrasted with Uvsa in a sec. It is a very high hill to climb, very steep hill to climb if you don't have that declaration, but it does not in and of itself prevent an application for a T visa. And one of those reasons is that we recognize that a lot of victims of trafficking, especially victims of labor trafficking, have had more success finding justice through the civil court system. So there is a civil way that this can go as well. One that I am not as familiar with, but happy to connect you with resources for that piece of it, if that's more aligned with how your survivor is engaging with the system. So what is being signed? We just sort of went through that. The bottom part, the attestation, as I walked you through the form. But at the beginning, there's also instructions that accompany this form. And this top part is those instructions. And that, again, can be helpful to remind law enforcement. One of the things that is in that sort of what is the purpose of this form paragraph is, by signing this supplement, you are not conferring an immigration benefit of any type. So that can, again, alleviate some of those common fears we see. This is the UNT Visa Law Enforcement Resource Guide. Might be helpful for you to use it when you're communicating with law enforcement. This might be a good resource for you. I know there's a ton of resources out there also for immigration attorneys, for pro bono attorneys that are hopefully supporting survivors of trafficking through this process. But it's always good to see kind of what the other side is looking at, not to put us at different sides of this coin. But sometimes when it comes to working with survivors to apply for immigration relief, it may feel like that. So this is a resource guide. It is out of date for the Uvsa portion of it. A year or two ago, they published a separate and distinct Uvsa resource guide that supplants this guide. They said that they were also going to do the same thing and issue a new T visa one. That has not been issued as of today, September 20th, 2021. But so when it comes to the T visa portion of this guide, we have confirmed it is still in effect and still good. So that's the really should just be T visa guide at this point. Should Photoshop that out, put a big X on it. So that's the T visa piece. But I want to move on to some of the other forms of immigration relief that may be available and may be more available to victim survivors that you're working with. So the Uvsa requires that the victim applying is a victim of a qualifying criminal activity. We'll talk about that. Possesses information about the crime. It's usually not a big hurdle. And that the criminal activity had to occur in the US or violated US law. Again, not a big hurdle most of the time. That's not where we're going to spend our time talking about this. There is a helpfulness requirement. It is these are all in the disjunctive. So the victim has to have been, are being, or likely to be helpful. And again, in the disjunctive, in the detection, investigation, prosecution, conviction, or sentencing. And they have to have experienced a substantial physical or mental abuse as a result. That particular piece of the application, I have in a different color on the slide to represent that the harm requirement is not something that law enforcement and prosecutors need to validate, check off. If they have evidence of harm that was caused by the criminal activity, they can support their victim's application by providing a statement regarding to that, but it's not something that law enforcement is ever asked to sort of check off or sign off on. So that piece is going to be established by the victim's attorney or advocate that is helping compile the full application. The Uvsa facts. In this case, there are 10,000 U visas allotted per year. That number is exceeded by the thousands every year. And there is currently a very big backlog on U visa applications and U visas themselves. I'll talk about the timeline on the next slide. If granted, the U visa allows for a 4-year stay. And again, we've got the employment authorization. We know it's just so key to stabilizing victim survivors of any type of crime. There's derivatives visas for certain relatives, And again, there's this pathway to lawful permanent residency and citizenship after a certain time has passed. And there are additional sort of requirements, including proof of good moral background, and at multiple stages through the entire process. There are background checks, biometric checks, and all of that. And again, USCIS is in charge of all of that. And the law enforcement prosecutor, they're in charge of a very small gatekeeping function, which is the Uvsa certification. So the Uvsa certification must be completed before a victim can file or apply for a U visa. It is a do not pass go, do not move on. It needs to have that certification. There is no exception. So this is really important for survivors. This can be a hurdle, right? Because you need to have law enforcement or judge or someone sign off on the U visa, or you cannot file the application. The application is typically compiled by an attorney or an advocate. It can be several inches thick as opposed to the certification, which is 4 pages or something like that. The decision is by USCIS. These numbers, again, are constantly being updated, but through my work, I have learned or heard that that decision takes about 5 years. So the application to decision is 5 years of pending. So again, I pointed out the timeline with the T visa and said, pay attention because this timeline is going to be really important when you make your decisions of how you should proceed. And then even if the decision is made that, hey, you qualify for a U visa, there's an additional 4-year waiting list to get the actual visa because the 10,000 is exceeded so far every year. So we're looking really at a decade before someone gets a U visa like in their hands. However, there are protections along the way. As soon as the certification is filed, the application is filed, there is that red flag that goes into that victim's file, which really protects them for initiation of deportation proceedings. There are certain protections that come along with that, including, there's meant to be no enforcement in courtrooms. They are not meant to take any tips from the offender on their U visa cases. So there's some limited protection just at the point of application. So it's definitely a worthwhile process if this is indeed the best way to go forward with a victim of trafficking. And like you might suggest to a victim of domestic violence who has a civil protection order, we would recommend to victims that have a signed certification for a U visa, keep a copy with you in case there's any interaction with ICE or something like that. And so they are this process. There's been some movement as far as certain benefits getting maybe conferred a little bit earlier, including work benefits when USCIS has made like a probable cause determination. So this is information and changes that have been made in the last weeks to months. So if you want any more like deep dive information on that, I'm happy to help you to learn like day to day what's happening with this U visa, because there's really a large call to reform this, to get this process going faster, or to increase the number of visas available so that we can stop this backlog. So we really are looking day to day for updates. The certification, they must submit the signed certification to apply. We talked about that. Again, when we're talking with law enforcement and prosecutors, stressing the fact that this is a gatekeeping function, that the certification itself does not confer any visa, any citizenship, anything like that. It likewise can be revoked by providing USCIS more information. And it must be submitted with this full application. It used to be able to be submitted first, but now it is submitted with the full application. The helpfulness, again, is usually where the rubber meets the road when we're talking to law enforcement and prosecutors. These are the questions that are being asked on the Uvsa. Does the victim possess information concerning the criminal activity? Has the victim been helpful? Is the victim being helpful? Or is the victim likely to be helpful in the investigation or prosecution? And then, since the initiation of cooperation, has the victim refused or failed to provide assistance reasonably requested in the investigation or prosecution of the criminal activity? And I'll see if I can do the same thing I did last time, which it sort of worked, right? Let's see. So this is the certification or supplement B for the Uvsa. And you'll see again, victim information, agency address, agency information, all of this filling out. It has what criminal acts. We're going to go through that in a second. So there's a list of criminal acts. It asks you for the date. It asks you for any statutory citations related to those criminal acts. And then, did it occur in the United States? Where did it occur? Some federal jurisdictional stuff doesn't come up very often. Briefly describe the criminal activity. Briefly describe any injury that may have occurred. If none is none. Helpfulness, we just looked at that. Some extra information if you want to add it. Family members culpable in criminal activity. 75% of Uvsa applications are for domestic violence or sexual violence. 75%. So the family member in a lot of those domestic violence cases, that's going to be a big piece of that. And again, it's to protect the victim from basically threats of deportation from that person. And then there is the certification, and that's the entire supplement B. There's some room for additional information here, but that's it. It's 5 pages. So again, just to sort of alleviate folks' fears about this. And hopefully we're back there. So this is the qualifying criminal activity. You saw that on the form really briefly. This is taken from that. So a couple of things I wanted to point out. Number one is that it is qualifying criminal activity. It is not what crimes were committed. And the reason that it's sort of written this way is because we're working with 50 plus criminal codes, criminal statutes around the country. And so for the federal government, they cannot name every crime, every statute. We all call things different. California, they call it rape. In Florida, they call it sexual battery. In New Hampshire, they call it sexual assault. So we can't incorporate all of that there. So instead, they use some sort of more general terms that are meant to encompass a sort of range of criminal activity. So you'll see here, domestic violence, for example, is a great one. Very rarely is there actually a statute that is domestic violence. It's usually like assault or battery or other crimes, and then there's a designation that it is a domestic case. And so you don't really have a domestic violence statute as related to a criminal code. So that's an example of why they use this type of criminal activity language. So looking at this criminal activity, you'll note that many of these crimes are either directly or very closely related to human trafficking. Involuntary servitude is here. Peonage. Trafficking is here. Prostitution. Fraud in foreign labor contracting. False imprisonment. Abduction. Sexual assault, sexual exploitation, or abusive sexual contact. We know that is incredibly common in cases involving labor trafficking and obviously sex trafficking, where there are immigrant victims. So while the T visa is the preferred visa, if you are working with a victim that you think has pretty demonstrable case that they are a victim of a severe form of human trafficking. But we know that around the country, law enforcement and prosecutors are struggling to really keep up with the really great work that victim service providers are doing and academics. And we really still see under-reporting, under-charging of trafficking incidents. And so you'll often have prosecutors who say, well, I'm not going to charge trafficking, even though that's kind of essentially what it was. I'm more comfortable charging the sexual assault that was a part of the coercion and force. I'm more comfortable charging the witness tampering that was after the reporting of the crime, or the false imprisonment because they weren't allowed to leave. And so this allows a little bit more room for someone to apply for immigration relief when they may not be able to get somebody to sign off that they were a victim of trafficking. And I would highly encourage you, whether trafficking is charged or not charged, still to make the call to have the T-Visa endorsement declaration signed by law enforcement. We know it's not typically the fault of the victim, or even the fact that the victim wasn't a victim of trafficking. There are a ton of other reasons why prosecutors don't go forward with a particular charge. So the charge is not required for the T-Visa. It never says, was this person actually prosecuted and charged with this crime? No, it is always, was the victim a victim of this crime? So we really want to look at through the victim's eyes. However, I'm going to push for the T-Visa. I think it's really important to recognize that that may not be possible in all of your cases. And so the U-Visa is kind of a good backup, or you may have a case where really they are a victim of some exploitation and it just really doesn't rise to the level of severe form of trafficking. So these are a lot of criminal activities. If you're filling out the certification or you're asking someone else to document what the criminal activity is, you want to check off as many of these as possible, because the victim has to prove that the harm that they experienced is related to the criminal activity. So in cases of domestic violence, as the chief of litigation for Miami's misdemeanor domestic violence unit, I was signing certifications for U-Visas. And even if we just went forward, let's say, on a violation of a protective order case, because that was something we could easily prove, it was witnessed, it was like boom, 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 easily done, I might still check off because I know the facts of the case. I read the report, I saw the evidence. I may check off this person was in fact a victim of domestic violence, a victim of witness tampering, a victim of stalking, and provide that to the immigration attorney or advocate, because that's much more likely going to be how they connect the harm to the criminal activity. Even though I didn't go forward with those charges, that's not the victim's fault. I'm looking at it through the eyes of the victim. What did they experience? It also includes attempt, conspiracy, or solicitation to commit any of these crimes. Obviously, that's at the bottom of here. And then before we move on, one last thing is that not necessarily directly related to trafficking, but we often get the question of, what about robbery? Robbery is not on here, including armed robbery. But we have seen a lot of immigrant victims being targeted for robberies. There were a span of cases that occurred. It was related to a co-occurring labor trafficking case in the south of Florida, where a lot of robberies were occurring like basically right outside of check cashing stores. So our theory of the case was that somebody had thought, oh, these are going to be undocumented people cashing their checks on Friday, and then we can just rob them, and they're never going to go to the police, or even if they go to the police, they're never going to be, participating in the investigation. This is a really great plan for me to get away with all these robberies. So in that case, we're thinking, okay, we want to support those victims because, again, big picture, we're building relationships with this community. We don't want this entire immigrant community just to be open season for offenders. But we don't have armed robbery on here. So we're thinking about other ways that we could do that. So sometimes, depending on the facts of your case, you could check off felonious assault. Right? That's going to be your armed robbery. Is really almost always also a felonious assault plus a theft, right? Depending on the facts of the circumstances, it might be false imprisonment. These people, while being held at gunpoint or knife point, they were not allowed to leave. Kidnapping, if it happened in a store, we had a mini mart, a victim who was a cashier at a mini mart, and they were held in the back room while the robbery occurred. That could be your kidnapping. So you can be creative here because, again, it doesn't matter what charges were brought or what this, matching it perfectly with a statute number. It's really, what did the victim experience from their perspective? We want law enforcement and prosecutors to take a victim-centered approach. So this is where that conversation about, this isn't about your case, this is about this bigger picture of community relations, about protecting survivors, about not letting offenders be able to just have free reign and take advantage of an entire swath of vulnerable folks in our communities. So with that in mind, the UVs and the TVs are set up that it does not require a conviction. It doesn't require that charges even be filed. So none of this is required. It could be beyond the statute of limitations. An offender could be dead. They could have been deported. You could never even know who the offender is through a victim-centered approach. So again, this is a place where you may need to, sort of educate and connect who you're asking to certify with some additional resources or with those guides that we provide links to. This, again, is this piece, which is, since the initiation of cooperation, has the victim refused or failed to provide assistance reasonably requested in the investigation or prosecution of the criminal activity detailed above? So this is the ongoing requirement that U visa applicants have. And likewise with the T visa, there is also an ongoing obligation for the certifier to let USCIS know if anything changes. So this ongoing responsibility, obviously law enforcement and prosecutors, we like that because it makes us feel better that we're going to have a victim when we're ready to go to grand jury or try a case. But at the same time, they don't want us to have to wait until, conviction, all appeals have been exhausted, and then, okay, now we can finally sign. So which is why there's this kind of push to sign early. We all saw that timeline, and then have an ability to sort of provide more information if we need to. However, these cases often involve really complex dynamics. So I also always talk to prosecutors and law enforcement about what it means to unreasonably refuse, what is reasonable in these contexts, because this nature of victimization is really high. The fear of offender, and it's not just fear of physical violence. We talked about all the other collateral fears that come with deportation and family separation. We know the trauma, all the different tactics that an offender uses to assert power and control, or force, fraud, and coercion. In the totality of the circumstances, we know it might be perfectly reasonable for someone not to participate in the criminal justice system. Without the added factor of, unstable immigration status, without that, we know how difficult it is for victims of sexual violence, domestic violence, and human trafficking to participate in the criminal justice system. There are so many barriers. The system is not set up for them. And so I don't think it's really unreasonable that any victim not necessarily engage in the criminal justice system. So I always want to share that when I'm training law enforcement and prosecutors to be like, what is reasonable? What do you expect from them? What have you done to help them in these circumstances? How can they possibly be supported to actually do this? But we also know there's a lot of witness intimidation going on above and beyond all of that. So another consideration of why someone might appear that they're not cooperative, or they really are not able to participate because of threats or intimidation or extortion or actual harm that's committed to their family, maybe in the country of origin. So before I have any law enforcement or prosecutor sign, hey, you know what, this person did unreasonably refuse. They didn't come to court when I needed them to, or I couldn't locate them. First off, be realistic of what your expectations are. Did you really look for them? For a victim of domestic violence to not be in the same location they were at the time of the abuse, now you're looking for them a year and a half later, maybe not their fault. So go through all of that process with them. And then I'd tell them, listen, instead of just refusing to sign, which a lot of people will do, they'll just throw it away. Instead of that, you can actually check no to that question. You can provide an explanation and say, hey, this person was personally served with a subpoena. I contacted them several times via the phone, and they still did not appear in court. I offered them transportation. I offered them childcare, and they still did not come. You could provide that explanation, and then you give it back to, the attorney or the advocate who is seeking this. And so if you were the attorney in that case and you got that on your certification back from law enforcement, you might think twice, like, I may not submit this to USCIS. Now, you can submit it, right? All you need is that signed certification. It doesn't matter what the answers on that certification necessarily are. So you could submit that, but you could probably guess that it might be a very steep hill to climb to convince USCIS that the applicant is deserving of the U visa. So more often than not, what happens is the advocate or the attorney will say, go back to law enforcement and say, oh my gosh, I didn't know about this. She moved. She's staying with her sister. She doesn't have any way to get to the courts and she doesn't read English. So let's try to fix this. So this is another place where that sort of communication between the victim's advocacy team, their service professionals, their immigration attorneys, can really be bridged with law enforcement and prosecutors that are sitting there going, hey, you want me to sign this, but you're not doing what I ask. Fair or unfair, that's a place where this can sort of fall apart, or it can be improved and that bridge can be built. So if ultimately you cannot get this certified by somebody that, let me go back to this. So since the initiation, has the victim refused or failed to comply? So you've got your prosecutor is like, nope, you ruined my case. I was prepped for trial and you didn't show up and I had to drop it. I'm not signing this. I'm going to say yes. I'm going to say yes. From your perspective, working with the survivor, you have to kind of figure out, okay, do I still apply? Do I think that we have a good enough reasons to apply? Or maybe if there's a concurrent family court case going on where the victim survivor has been attending because that's where the childcare situation is up and that's where the divorce is up, and that judge actually has all that information, they can be like, okay, well, prosecutor, thank you anyway. I'm not going to have you sign. I'm going to go to the judge. It's perfectly allowable to do that. But obviously, this is, part of your job supporting the victim is to help them understand this process. And again, it's completely discretionary on that certifier. They can never be made to certify. Okay, and then again, this is that language about what is being signed. It mirrors the T visa language of, I'm not promising citizenship. I believe this to be true, and I will let USCIS know if anything changes. This is the new U visa law enforcement resource guide I mentioned. I guess it was released in 2019. I have lost all sense of time and place, but I guess 2 years ago now at this point. So that does supersede the other resource as far as the U visas go. Okay. Continued presence, sometimes referred to colloquially as CP, which always confused me. If any of you have worked in cases involving child pornography, that is the same. They call that CP as well. So I really have to get my brain to rethink what we're talking about when we talk about CP. But you'll hear this from law enforcement and prosecutors. They'll refer to it as this way. So I wanted to make sure you're aware. This is a temporary immigration status. It's provided to victims only of trafficking who are sponsored by federal law enforcement. This is probably the most problematic piece of CP. CP should be an incredibly helpful tool, and it is when it works correctly. But they included this language called sponsor that has to be sponsored by a federal law enforcement. And I think a lot of people are really afraid of that language. You don't want to be like, oh, I'm signing this and therefore I'm like taking on this person as like my foster child or something. I'm sponsoring them in the United States. So I think personally that's a barrier to accessing what really should be an incredibly helpful tool for us to stabilize and investigate human trafficking cases. The other problem that we often see in my work is that it has to be going through a federal law enforcement agency. And so T visas, U visas, it can be local, state, federal, they can all sign equal opportunity. CP, it has to be a federal law enforcement officer that is on board with sponsoring this victim. So when I work collaboratively around the country, I'm working with a lot of task forces. Those task forces have state, local, and federal partners. And one of the reasons, there's an abundance of reasons, but one of the reasons why it's so important is that there has to be a trusted relationship so that when a local law enforcement agency is working on a case involving an immigrant victim of trafficking, they can go to their federal partners and say, hey, you know me, you know the work I'm doing, you know that I wouldn't ask you this if I didn't think it was right, but this victim really should be have CP. Can you sponsor them based on our relationship? So sometimes we hear that works fairly smoothly. Other times we hear that federal agency will insist upon taking over the case from the local one, or at least having a concurrent case open. So there's some disparity in how this works sort of logistically around the country. There is a huge push to improve this. There were a couple of months ago, some listening calls that USCIS or DHS put on talking to folks that are on the ground. And I was involved in those calls and the outcome of that and sort of trying to figure out how can we get more folks to use CP for the way that's intended to be used. The way that it's intended to be used is that it's it's almost like a immediate stopgap for victims of trafficking as soon as they're identified. Like before investigation, before prosecution, as almost immediately upon identification, continued presence can be applied for. Cooperation is not required. The purpose of this really is meant to be, I think that's a victim of trafficking. Let us give them some protection, some safety, some room to breathe so that we can do our investigation. Upon approval, the continued presence process through the federal agencies, upon approval, the Department of Health and Human Services comes in and allows that victim that has continued presence to access federal and state benefits and work authorization. Now, interestingly, cooperation is required to access those benefits. So while CP can be given without cooperation, if you want the separate sort of benefit piece of it that's typically attached, that cooperation is required for that. But you could imagine how helpful this would be for an immigrant victim of trafficking to almost immediately be able to work, access benefits, and be basically capable of hopefully accessing all these services and then be able to say, okay, well, let's sit down with the investigator. And now we're not in a rush. We have time. We have space. We can get this person some services and some breathing room. So incredibly, incredibly helpful tool if used correctly. It is granted for 2 years. Originally, it was for 1 year, and it could be renewed. And it was like 99% of them had to be renewed just because the length of human trafficking investigations, it just takes forever. And because it's usually used in conjunction with a T visa, and the T visa waiting line is 2 years. So now continued presence is automatically at the outset for 2 years, and it can be renewed. It doesn't guarantee access to any other form of long-term immigration relief. So it's not an automatic, now you get a T visa. It can also be revoked. And here it's really important that it can be revoked because of the immediacy of applying for it. By necessarily, investigators and prosecutors, they don't have all the information they need to make like a really a solid call of whether this person is a victim or not. And because we want it to be done almost immediately, we also want to assure folks that it can be revoked if we found out, no, wait, you're not a victim at all, or you're actually the perpetrator, or perhaps you're even a U.S. citizen. You never know. So you can be revoked. So this is how it normally works in conjunction with the T visa. Get the continued presence right away, and then start working on the law enforcement endorsement or declaration, and then put together the application, and then get to USCIS. And then continued presence serves as that stopgap while the T visa application is getting compiled and submitted. If done correctly and smoothly and everything's in place, you can get continued presence in less than 30 days, in sometimes as little as 10 days. So very key. A couple of hurdles as far as the language and the need for a federal law enforcement agency to be involved, but still obviously an incredible tool. Now, the other thing I just want to mention is this deferred action, which is, I don't want to say informal, but sort of an informal immigration status. And when we train across the country, what we've been hearing is that a lot of law enforcement officers, instead of using continued presence, they use deferred action, probably just because they're more comfortable with it. It is a little bit less formal, probably isn't as scary for them. And it's been used for years for all sorts of cases, including cases that involve just like a cooperating witness on a drug case or something. Law enforcement have used this where they just basically call their, I'm exaggerating, but they just call their buddy up at ICE or USCIS and say, hey, I've got this guy, I'm working with him, can you just like not deport him for a while? So it's a little bit more formal than that, but deferred action needs to be directly requested from law enforcement. It's 100% discretionary. There's really, that I know of, and I probably wouldn't say I was an expert on deferred action. I don't think there's any requirements. It's just an approval from USCIS. It delays any deportation proceedings, but it does not confer any benefits, no access to services, no work authorization, no path to anything else. It's really just almost like a favor for law enforcement who are working with somebody that they don't want deported while they're doing this case. It does provide USCIS this person's personal information, so it could actually be risking survivors or victims, and it really should not be used. USCIS is very clear about this. It should not be used for victims of trafficking, although we know it often is. So if you've got somebody who is under this, you really want to push for continued presence in lieu of that. This is the latest brochure that the Blue Campaign has put out on T visas. It's 2 pages. I just have the first page here with the facts, the FAQs here. But good news is that's all we had before about continued presence. But 2 months ago in July, they did put out a continued presence resource guide for submitting law enforcement agencies and civil attorneys. So this might be a really great resource for those of you that are maybe thinking or working with currently a survivor of trafficking who is not engaging necessarily with the criminal justice system, but through some civil procedures. And so you can look at it there. Okay, I've got a couple of case scenarios that I thought we could just use to synthesize some of what we've been talking about. In this case, Agnes is a young woman from Uganda, has been working in the home of her wealthy relatives. She came to the US 5 years ago, and she was promised to attend school here and have money sent home. She never attended school and was regularly beaten and raped by these wealthy relatives. Agnes disclosed the abuse when she went to urgent care after trying to give herself an abortion. Her relatives have returned to Uganda and cannot be located. The factual scenario here is based on some real cases. So what we want to think about is, does Agnes qualify for a T visa, a U visa, and are there any obstacles here? This is a pretty egregious factual scenario. And so we probably have her on both trafficking and several crimes under the U visa as well, including rape. And so she would apply most likely for both a T visa and a U visa, preferably the T visa. And she could demonstrate the hardship to return to country, which is sometimes more difficult than you would imagine because her wealthy relatives, the perpetrators, have returned to the home country. Now, the problem might be that you might be working with law enforcement or prosecutors and asking them to sign, and they're like, well, I don't have a case. Like, I don't know who these relatives are. Maybe she can't even identify them. Maybe she has identified them, but they've been deported and you don't really think you're ever going to get a case out of it from the perspective of law enforcement and prosecutors. So again, this is just a bit about trying to help educate the partners about what is and what is not required. And Agnes looks like she qualifies for both a T and a U visa, the T visa being preferred. George, or Jorge, was identified as a potential victim of labor trafficking after OSHA shut down a factory for unsafe conditions. Jorge and 5 other men from Ecuador, they lived in company housing, which did not have running heat or air. During his first interview, he denies being forced to work, but he did disclose that he was tricked into the job, and he asked the police if they could get him his passport back. He says that he's willing to speak about the factory and how they withheld some pay for food and housing. So this is a situation where continued presence would be a perfect tool for law enforcement, because while Jorge is saying he wasn't forced to work, he most likely doesn't really understand what human trafficking, what the definition is, and what was happening to him. So always these common red flags of somebody not talking about, oh, I was being trafficked, but I was tricked, right? And then of course we added in some facts about he doesn't have a passport, the living conditions, the pay being withheld. So continued presence would be a really great tool, and most likely down the line would be a good applicant for a T visa if the facts kind of shocked out, and also potentially a U visa. We've got some fraud and foreign contracting that might work here too. Marvin is Canadian, but works in North Dakota for his uncle, a tribal elder who manages a casino. Marvin is on probation for selling drugs, and his uncle has threatened to call his probation officer and report that he's using drugs if he doesn't work as he's told. His uncle is involved in a scheme where a local store owner is laundering money through the casino and paying employees with poker chips to hide their employment. The local store owner is trafficking about 10 to 15 people, and Marvin can help identify the victims and explain the money laundering scheme to police. So Marvin's a potential witness to this money laundering, trafficking situation. He potentially is also a victim of labor trafficking himself because of his uncle threatening him to get him rearrested if he doesn't continue to work as promised. Marvin's not a perfect guy here, but that's not necessarily the call of the local law enforcement and prosecutors who are being asked to sign the endorsements or the certifications. That might be something that trips him up when USCIS is reviewing everything, but he technically would probably qualify. And you might want to help Marvin because while his case you might not have as much sympathy for him. He's Canadian, it's his uncle, he's on probation for drugs, but it looks like he could really help you with this larger trafficking scheme and money laundering scheme. And so therefore, you may want to kind of go above and beyond to get the bigger fish here. And so that might be a situation that law enforcement struggles with a little bit, but may actually be more familiar with because they do this all the time in drug cases and gang cases. So it might actually be more familiar to them. So a couple of commonly asked questions. How will this affect my case? Can we just wait? So this is from the perspective of law enforcement and prosecutors. These are what they ask when I train them. How will this affect my case? Why can't we just wait until the end? What if we can't charge it as trafficking? And how can I ensure that I'm not responsible for subsequent bad acts committed by the victim? What if the victim's lying? What if I'm just not comfortable signing? So I think we reviewed a lot of these within the materials. The signator, the certifier, the person who signs the endorsement, they are not responsible in any way, shape, or form for the victim. Neither is the sponsor on continued presence, even though that word really does kind of make you think they might be. They are not. So alleviate some fears there. Also, this fact that you can always revoke, you can always provide USCIS with more information. That can help with some of those other places where they struggle. And there are a ton of strategies for prosecutors to deal with this in court. There are some key things that prosecutors and law enforcement need to know, but there are ways and strategies to overcome this. And waiting is doing the opposite of the original intent of the U visa and the T visa and continued presence. It's all about getting services and protection for victims. And that should be our first priority. And then we can strategize as prosecutors how to help. So when you're working with law enforcement and prosecutors, you can always give them my information. These are other resources that I look towards. I work very commonly with NUOP, or the National Immigrant Women's Advocacy Project. So most of our training and technical assistance is through them. So great number of resources available. Some other listed is here. And the last thing I just wanted to end you with is that prosecutors will have to provide the certification, the endorsement in discovery. So that certification form, that endorsement, that is discoverable. Anything that law enforcement prosecutors provided you as accompanying that, if we gave pictures or police reports, that's discoverable. Any communications might be discoverable that accompanied, here's the certification form, please fill it out, kind of thing. That could be discoverable. Anything that you, advocate or civil attorney, provides me as prosecutor or law enforcement, that's also discoverable. So best practice is not to provide any of that accompanying documentation, medical records. None of that is necessary to complete that certification form, that declaration form. I don't need it. I don't want it. If you do give it to me, it becomes discoverable and it's not necessary. The immigration file itself is also not discoverable. So happy to be a resource for all of you as you try to support victims' applications for immigration relief. We can help you leverage those resources that are out there and give you tips and tricks of how you might better communicate with prosecutors and law enforcement that you're hoping for their support as well. And this is all of my contact information. So it's been a pleasure providing this information. Thank you all for participating in this amazing event. And hopefully we can continue to support your work.
Thank you everyone for attending today's Triage CLE. The last CLE code for the program is GHL 442. So G is in Gary, H is in house, L as in Larry, 442. And as a reminder, you'll get a follow-up email with the CLE form and also instructions on how to access our virtual training library, which includes other CLEs and trainings related to human trafficking. If you're not already on our human trafficking volunteer list and would like to join, please either reply to that email or to contact me directly, and we would love to have you involved. Have a good day.